Hello and welcome to Module 10 of Estate and Probate Management. In this module, we shall be looking at preemptive planning, divorce implication, cultural factors, and global stroke recent development. This is integrating legal rigor, cultural sensitivity, and technological awareness. The model content here includes savings family stress, step-by-step guide to will, trust and power of attorney, divorce law in Nigeria, that is property distribution under matrimonial court acts, then why Nigerians avoid will, the cultural religious barrier and solution. Then we'll also look at divorce and estate probate law comparison of UK, USA, uh, European Union, Ghana, Kenya, Nigeria, Australia, South Africa, and Canada. We'll also look at firms in Nigeria, how and where to find them. We'll also look at recent development, that is digital wills, crypto estate, 2025 reforms, before we draw our conclusion. Let us begin with the introduction. Why preemptive planning matters. The core challenge is without proper planning, family face the following problem. One, prolonged legal dispute, financial stress, emotional strain, fractured relationship. Nigeria's unique context is involved that there is diverse culture, religious, and legal landscape. Many hesitate to use will, trust, or power of attorney. Result, estate becomes entangled in probate. Modern challenge is digital assets like cryptocurrency, online account, cross-border estate, and divorce implication. Therefore, preemptive planning is equal to protecting the family and preserving your wealth. Now let us look at the three critical legal instruments. Number one, the will. The purpose of a will is to set to that is asset distribution after death. The advantage is that it appoints executor specified beneficiary. Trust. The purpose of trust is asset management by the trustee. The advantage is that it bypass probate and protect your asset. Then power of attorney, the purpose is organize or authorize agent to act. Then the advantage is that it manages affairs if incapacitated. Standard probate delay is usually 6 to 18 months. Proper planning can avoid this entirely. Having known that, let us look at step-by-step guide to will. Creating a valid will in Nigeria. One, you have to invest all your assets like real estate, bank account, investment, digital asset. Two, identify beneficiary, the primary beneficiary, alternate, charity and minors. Then three, appoint an executor, that is trusted person or professional like bank or trust company. Four, comply with legal formalities, sign in the presence of two witnesses, not your beneficiary. Then five, review and update them regularly. After marriage, divorce, birth, or major acquisition, you have to review and update on regular basis. Tips: store your will safely, like in a bank, lawyer's office, or digital vault. Now let us look at trust and power of attorney. Trust, that is bypassing the problem. So choose the type like revocable or irrevocable or special purpose trust. Then select your trust, either individual or institution. Then fund the trust, transfer the asset, then draft trust deed, and then monitor and review them. Then power of attorney. The general power of attorney, broad financial and legal power. Then we have limited power of attorney, specific purpose and time. Then important note is that power of attorney dies without donor in Nigeria and cannot be sued and cannot be used for estate distribution. So having known that, let us look at the divorce law in Nigeria. That is the governing law, which is Matrimonial Court Act. According to Section 72, it empowers court to make property settlement for benefit of spouse or children. What is matrimonial property? These are assets acquired during marriage. It excludes pre-marriage property, inheritance, or personal gift. The key principle is that joint contribution rule. So the principle of this Matrimonial Court Act is joint contribution rule. Nigerian court recognizes both financial and non-financial contribution. So anything you jointly acquire, under marriage is known as joint contribution, and it is distributed according to joint contribution rule. So homemaking and child rearing is equals to valuable contribution. Having known that, let us look at property distribution after divorce. That is the cost consideration factor. The court will consider the following factor: contribution, what it means, both financial and non-financial contribution, that is homemaking, career, and support. So the court will consider your contribution in the marriage. The court will also consider the need of the party, that is their age, their health, future earning capacity. Then the court will also consider the welfare of the children, that is primary contribution, may allocate matrimonial home. Then the court may also consider the conduct, that is rarely decisive but reckless dissipation may affect the decision. So the court powers property adjustment order, settlement of property, maintain order, then custody and child support. It is critical. Divorce does not automatically revoke a will in Nigeria. Update your will after divorce to exclude former spouse. So once you have a divorce, first thing you need to do is to update your will, because divorce does not automatically revoke a will. So why Nigerians avoid will? So Nigerians avoid will because of certain factors like cultural, religious, and practical barrier. So the barrier includes death invitation mind, that is description, writing a will involve inviting death. So solution here, rebrand it as wealth protection or family legacy. So do not use the term writing a will, but rather use protecting your family legacy or wealth protection. The religious misconception, uh, some Nigerians believe that only God determines your future. So solution: engage religious leader, both Islamic and Christian, support orderly inheritance. Then lack of awareness is another factor. Some of them don't know importance or process of will. So solution is that legal literacy program and simplified services should be offered. Then fear of conflict. Some of them believe that writing a will may create family tension. So solution here, family discussion and neutral practitioner. Then distrust of the institution. There is also fear will tampered with. So they have the fear that the institution may tamper the will. So here, register your will and use reputable lawyers. Then the cost. Some of them believe that writing a will is very, very expensive. So they assume that it is expensive. The solution means low cost program and non-governmental organizational services. So these are why Nigerians avoid will. Having known that, let us look at global comparison, and that is divorce and estate. So we now compare Nigeria, UK, US, as well as South Korea, South Africa, Australia. Now in Nigeria, will stay valid. That is divorce impact on will. So in Nigeria, will stay invalid. Then probate speed is very slow in Nigeria. Then the key fee is usually 10% of the estate. Then in the UK and Canada, divorce impact on will is that ex-spouse is treated as is dead, as dead. Then it is fast. And the key feature is that in UK and Canada is high inheritance tax in UK. Then US, the divorce impact on will is that it is automatic revocation, and it is varied by state. So the probate speed varies, maybe it varies according to state. Then the key feature is that it is extensive use of trust. Then in Ghana and Kenya, the divorce impact on will is similar to that of Nigeria. Will stay valid. Then the probate speed is moderate, and the key feature is that recent land digitization. Then in South Africa, the divorce impact on will is that it is 3 month grace period. So they will give you 3 months grace to update your will. Then the probate speed is moderate. Then the key feature is strong customary law integration. Then in Australia, the divorce impact on will is varies by state. Then the probate speed is moderate. Then family provision claim is the key feature. Then global trend, no force divorce adopted in US, UK, Canada, and Australia. So there is no fourth divorce adopted in these following uh, countries. Now let us look at comparative legal framework, the key observation across this jurisdiction. There is no fourth divorce trend in US, UK, Canada, and Australia. Then spousal protection. Most jurisdictions ensure spouses receive a part of the estate. Then customary law influence are eminent in Nigeria, Ghana, Kenya, and the statutory and customary system coexist. So then the probate standardization, Western countries is structured system, then African countries is formal plus traditional practices. In European Union, special features include succession regulation, that Brussels 4, which allows choice of national law to govern estate. Having known that, let us look at how to find law firms in Nigeria. That's the reliable source. We have Nigerian Bar Association, NBA, Methodist, Official Directory, that is Verified Active Statute. We have Corporate Affairs Commission, Verified Firm, where you can verify firm registration. We have legal directories. We have over legal 500, 500 legals, legal 500 rather, chambers and partner. We have Matandale Hobel. Then we have online platform like Law Paddy, Lawyers and Nigerian Directory. We have court registries where you identify lawyers through court cases. We have professional referrals like other lawyers and business professionals. We have social media like LinkedIn, Facebook profile. Then we have corporate trustee like SEC license firm and all that. So Nigerian Bar Association Directory and Corporate Affairs Commission record are the most authoritative source. Now let us look at the recent development in the estate and property management, that is digital will. So digital will, that's electronic will, is being created, signed and stored electronically. In UK, Wills Bill 2025 proposes electronic creation and witnessing. So the benefit of this digital will is that it is easier estate planning, it facilitates remote assets, it also reduces administrative delay and secure digital record keeping. The challenge is that it may result to fraud and undue influence risk. Cyber security concern is a challenge. Then there is need for authentication and audit trails. Many jurisdictions require government approval storage system. Now let us look at crypto estate and digital asset. That is digital asset requiring estate planning. So we have uh, cryptocurrencies like Bitcoin and Ethereum, online businesses, non-fungible tokens, social media account, digital intellectual property. Then the key legal issues is that access control. Private key is required. Beneficiary cannot access without authorization. So legal recognition, traditional probate law, uh, not designed for decentralized assets. Taxation, digital assets now treated as taxable property. Solution, list digital assets explicitly in your will. Provide a executor with secured access instruction. Then use digital asset management services. In conclusion, the key takeaway, that is essential element for modern estate management. Preemptive planning, that is will, trust, and power of attorney protect family harmony. Divorce awareness, update estate plan after matrimonial breakdown. Cultural sensitivity, address barrier through education and engagement. Global perspective, understand cross-jurisdictional differences. Technological adaptation, embrace digital will, crypto estate, e-probate. The final thought, estate planning is not about preparing for death. It is about protecting family members and ensuring fairness after death. By combining legal rigor, cultural sensitivity, and technological awareness, practitioners can ensure estates are managed efficiently, family stress is minimized, and both traditional and modern assets are protected. Thank you and have a nice day.